The billing alert hit my screen at 11:47 p.m. on a Tuesday, showing mediation fees I never authorized. I'm Beckett Lexington, 42, risk management partner at our real estate legal office in Scottsdale. 20 years of practice taught me to trust numbers more than people. Numbers don't lie, people do. The alert showed $15,000 in mediation consulting fees billed to the Morrison property dispute. I'd handled that case personally. Every hour, every strategy session, every client meeting. The mediation wasn't scheduled until next month. I pulled up the case management system. The timestamp showed the charges were entered at 3:22 a.m. last Thursday. I was home sleeping. My keycard logs confirmed it. Someone had accessed my client files. Someone with administrative privileges. The Morrison case involved a $4.2 million commercial property dispute. High stakes. High visibility. The kind of case that makes or breaks partnerships. I'd spent 6 months building the mediation strategy, every angle mapped, every weakness identified, every negotiation point calculated. Now someone else had billed consultation time on my case. I scrolled through the billing entries. The consultant listed was Meridian Mediation Services. I'd never heard of them. Their address showed a Phoenix office building I recognized. Expensive. Professional. Legitimate looking. But I hadn't hired them. The case file showed recent access logs. My login appeared at normal business hours. But there were others. Late-night entries. Weekend access. All using valid credentials, but not mine. I checked the client communication logs. 3 emails sent to Morrison's CEO last week. All from my account. All discussing mediation strategy. All containing information I'd never shared. The emails referenced settlement positions I hadn't disclosed. Negotiation tactics I'd kept confidential. Internal case assessments that should never leave our firm. Someone was feeding my strategy to outside consultants. Someone with deep system access. Someone who knew exactly which cases mattered most. I pulled the Morrison file from my locked cabinet. The physical documents told a different story than the digital records. My handwritten notes showed one strategy. The system showed another. Someone had been updating my case files, changing my approach, redirecting my work. The mediation was my signature case this quarter. Success meant a clear path to senior partnership. Failure meant watching younger associates take my place. I'd trusted our system, trusted our security protocols, trusted the people around me. The billing alert blinked again. Another unauthorized charge. This time for $8,500. Same mysterious consultant. Same impossible timestamp. Someone wasn't just accessing my files, they were actively sabotaging my biggest case. And they were billing the client for the privilege. The Morrison case hadn't started as my career-defining moment. 3 months ago, it was just another commercial real estate dispute. A Phoenix development company claiming breach of contract. Standard stuff for our Scottsdale practice. Then the numbers came out. $47 million in damages, media attention. Corporate executives flying in from 3 states. The kind of case that transforms associate attorneys into partners. They assigned me to handle their legacy clients to earn trust. Morrison Development had worked with our firm for 12 years. Their CEO, Clark Ridgewood, specifically requested me after our successful resolution of their Tempe project dispute last year. I'd built my reputation on mediation. While other attorneys preferred courtroom drama, I found power in negotiation. Reading people. Finding pressure points. Crafting settlements that left everyone believing they'd won. The Morrison strategy was elegant. Their contract included a force majeure clause that most attorneys would miss. Hidden in subsection 4.7.3, buried between standard boilerplate language. The opposing counsel had overlooked it completely. I'd planned to reveal this advantage during the third mediation session. Let them commit to their position first. then deploy the claws like a surgical strike. Clean. Decisive. Case closed. But someone else knew about my strategy. The billing alerts had started 2 weeks ago. Small charges at first. Research fees. Document review. Nothing that raised immediate flags. Our case management system, LegalTrack Pro, automatically flagged unusual billing patterns. These charges fell just below the threshold. I dismissed them as system glitches. Our IT department had been updating servers. Temporary anomalies were common during transitions. The first real warning came during a client call. Clark Ridgewood mentioned mediation tactics we'd never discussed, specific negotiation points from my confidential case notes. He assumed I'd shared them during our last meeting. I hadn't. That evening, I ran a complete audit of the Morrison file. Digital forensics revealed a pattern. Someone had accessed my files 17 times in the past month. Always during off hours. Always using legitimate credentials. The access logs showed my username, my password, my security clearance. But the timestamps didn't match my schedule. I'd been in court during 3 of those sessions. Home with my family during others. Someone had cloned my system access. I pulled the physical case files. My handwritten strategy notes remained unchanged. But the digital versions showed subtle modifications. Settlement ranges adjusted. Negotiation timelines altered. My careful mediation plan had been systematically undermined. The mysterious consultant charges led to Meridian Mediation Services. Their website looked professional, experienced staff, impressive client testimonials. But their business registration was only 6 weeks old. I called their listed number. Disconnected. The Phoenix office address led to a virtual business center. No permanent staff. No actual operations. Meridian Mediation Services was a shell company. Someone was billing our client for fake consulting services. Using my case strategy as the foundation. Selling my work to an imaginary firm. The pattern became clear during my investigation. Every major case I'd handled this year showed similar anomalies. Unauthorized access. Mysterious billing. Strategy modifications I'd never approved. Someone had been systematically harvesting my work. Selling it through fake consulting companies. Billing our clients for services that didn't exist. The financial scope was staggering. 43 unauthorized charges across 7 cases. Total billing, $127,000. All approved through our automated payment system. All using forged authorization codes. But the real damage went deeper than money. My mediation strategies were being leaked to opposing counsel. My negotiation positions were being sold to the highest bidder. My reputation was being destroyed one case at a time. I needed to identify the source. Someone with administrative access to our case management system. Someone who understood our billing protocols. Someone who knew which cases mattered most to my career. The suspect list was short. Only 4 people had the necessary system privileges. Myself, our managing partner, our IT administrator, and the associate who'd replaced me on the Henderson account last month. Daphne Ridgewood had joined our firm 18 months ago. Fresh from law school. Ambitious. Technically skilled. She'd impressed everyone with her quick adaptation to our systems. I'd mentored her personally. Shared my mediation techniques. Explained our client management strategies. Trusted her with sensitive case information. She'd been working late frequently, always eager to help with complex cases, always asking detailed questions about my negotiation approaches. I'd seen it as professional dedication. Now I recognized it as reconnaissance. The final proof came from our server logs. Daphne's workstation had accessed the Morrison file 37 times in the past month. Her login credentials had been used to modify my strategy documents. Her authorization codes had approved the fraudulent billing charges. She'd created Meridian Mediation Services using information stolen from my case files. She'd been selling my work to competing firms. She'd been sabotaging my cases while building her own reputation. The mediation was scheduled for tomorrow morning. Morrison Development expected my signature strategy. The opposing counsel was preparing for negotiations based on leaked information. My career hung in the balance of a case that had already been compromised. Daphne Ridgewood had stolen 18 months of my work. She'd embezzled over $127,000 from our clients. She'd destroyed my professional reputation while advancing her own. And she had no idea I'd discovered her betrayal. I confronted Daphne at 7:30 the next morning. She arrived early, as always, carrying her laptop and a coffee from the shop downstairs. Professional, prepared, completely unaware that her world was about to collapse. "We need to talk," I said, blocking her path to the elevator. Her smile faltered for just a moment. "Of course. About the Morrison case?" "About Meridian Mediation Services." The color drained from her face. Her laptop bag slipped from her shoulder. She caught it before it hit the floor, but her hands were shaking. "I don't know what you mean." I handed her a printed copy of the server logs. "Your workstation accessed my files 37 times last month. You modified my strategy documents. You created fraudulent billing entries. You sold my mediation approach to competing firms." She stared at the papers. Her breathing became shallow. "Beckett, I can explain. You embezzled $127,000 from our clients. You destroyed my reputation. You sabotaged cases I'd worked on for months. It wasn't supposed to hurt anyone." Her voice was barely a whisper. "I was just trying to build my own practice. The market is so competitive. I needed an edge. By stealing my work? By learning from the best." She looked up at me with desperate eyes. "You're brilliant at mediation. Your strategies are revolutionary. I thought if I could adapt them, modify them slightly, I could help more clients, while charging them for services you never provided. The billing was a mistake. I was going to fix it." "For 18 months?" She had no answer for that. I called our managing partner immediately. Clark Ridgewood arrived within 20 minutes, his expression grim. He had already reviewed the I'd sent him earlier that morning. "Daphne, these allegations are extremely serious," he said, settling into his chair. "We're talking about embezzlement, fraud, and breach of fiduciary duty." "I never meant for it to go this far," she said. "I was planning to return the money." "With what funds?" Clark asked. "You've been operating a shadow business using stolen intellectual property. You've damaged our firm's reputation. You've potentially exposed us to malpractice claims." The meeting lasted 3 hours. Daphne admitted to everything: the fake company, the stolen strategies, the fraudulent billing, the sale of confidential information to competing firms. She'd been more systematic than I'd initially realized. She'd created detailed profiles of our clients' negotiation styles. She'd documented my mediation techniques in a comprehensive manual. She'd sold this information to 7 different law firms across the state. "We have no choice but to terminate your employment immediately," Clark said. "We're also obligated to report this to the state bar." "Please," Daphne said. "I'll resign quietly. I'll pay back every penny. I'll sign any non-disclosure agreement you want." "The damage is already done," I said. "Our clients deserve to know what happened to their cases." Clark nodded. "We'll need to contact each affected client personally. We'll offer full refunds for any compromised services. We'll also need to report this to our malpractice insurance carrier." By noon, we'd contacted the authorities. Detective Captain David Lopez from the Interagency Task Force on Legal Finance Fraud arrived that afternoon. He was a compact man with sharp eyes and 20 years of experience investigating white-collar crime. "This is more sophisticated than most cases we see," he said, reviewing the SPUN. "She created a legitimate-looking business entity. She used professional billing software. She even filed quarterly tax returns." "How long will the investigation take?" Clark asked. "Depends on how many firms she sold information to. We'll need to interview her clients, examine her financial records, and determine the full scope of the fraud." The investigation revealed the true extent of Daphne's operation. She'd stolen strategies from 12 different cases. She'd sold information to 9 competing firms. She'd embezzled $184,000 from client accounts. She'd also been planning to leave our firm and start her own practice using the stolen intellectual property. Her resignation letter was already drafted. Her business plan was complete. She'd even secured office space downtown. The state bar moved quickly. Within 6 weeks, formal disciplinary proceedings began. Daphne's license was suspended pending the outcome of the criminal investigation. The Morrison mediation proceeded as scheduled. Without the leaked information, the opposing counsel was unprepared for my actual strategy. We secured a favorable settlement for our client within 4 hours. Other cases followed similar patterns. Once the stolen information was neutralized, my success rate returned to normal. Client confidence was gradually restored. Daphne pled guilty to embezzlement and fraud charges in October. She received 18 months in prison and 5 years of probation. She was also ordered to pay full restitution to affected clients. The civil lawsuits took longer to resolve. 3 clients sued our firm for malpractice. 2 cases were settled out of court. The third went to trial, where we successfully demonstrated that we'd acted appropriately once the fraud was discovered. Clark implemented new security protocols. All case files were encrypted. Access logs were monitored daily. Billing records required dual authorization. No single associate could access sensitive client information without supervision. We should have caught this sooner, he admitted during one of our partner meetings. The warning signs were there. She was careful, I said. She understood our systems better than most senior associates. That's what makes it so dangerous. She used our trust against us. The firm survived the scandal, but barely. We lost 4 major clients. Our reputation in the real estate community was damaged. It took months to rebuild the relationships that Daphne had destroyed. I testified at her sentencing hearing. The judge asked me to describe the impact of her actions on our firm and our clients. Trust is the foundation of legal practice, I said. When that trust is violated, it damages everyone involved. Clients lose faith in the legal system. Colleagues question each other's motives. The entire profession suffers. Daphne looked directly at me when I finished speaking. Her eyes were red, but she didn't cry. She'd lost everything. Her career, her freedom, her future-in-law. The judge sentenced her to the maximum term allowed under the plea agreement. 6 months later, I stood in my new office, overlooking Camelback Mountain. The view was different, but the work felt familiar. I joined a boutique firm specializing in real estate litigation. Smaller team. Tighter controls. Better oversight. My new partners, Clark Ashworth and Daphne Westfield, had recruited me specifically because of my experience with the fraud case. They wanted someone who understood the warning signs. Someone who could help them build stronger internal safeguards. Your reputation preceded you, Clark had said during my interview. We need that kind of vigilance here. The transition wasn't easy. Trust came slowly after what I'd experienced. Every new associate was scrutinized. Every billing entry was verified. Every case file access was logged and reviewed. But gradually, the paranoia faded. The new firm's culture was different. More transparent. Partners shared information freely. Associates were encouraged to ask questions rather than work in isolation. I'd kept in touch with some clients from the old firm. 3 had followed me to my new practice. They appreciated the continuity and the personal attention. You saved our deal, one client told me. When everything fell apart, you found a way to make it work. The real estate market in Scottsdale was recovering from the scandal. Other firms had learned from our mistakes. Security protocols were tightened across the industry. Background checks became more thorough. I'd also become involved in professional development initiatives. The Arizona State Bar asked me to speak at continuing education seminars about fraud prevention. Law schools invited me to discuss ethics and internal controls with their students. How do you spot the warning signs? A third-year student asked during one presentation. Trust your instincts, I said. When something feels wrong, investigate. Don't assume good intentions when the suggests otherwise. The question that haunted me most was whether I could have prevented the betrayal entirely. The answer was probably yes. Earlier intervention might have saved everyone involved, including Daphne herself. But dwelling on what-ifs served no purpose. The legal profession required thinking, learning from mistakes, building better systems. I advocate for laws protecting junior partners in disputes. The current regulatory framework leaves too many gaps. Associates face enormous pressure with limited oversight. The temptation to cut corners becomes overwhelming. My new firm implemented mentorship programs for junior staff, regular check-ins, open communication channels, clear escalation procedures when problems arose. Prevention is cheaper than prosecution, Daphne Westfield often said. She was right. The old firm had eventually recovered. Clark Ridgewood rebuilt the client base through careful relationship management. New associates were hired with extensive background verification. The security protocols I'd helped design became industry standard. Daphne Thornfield was released from prison after serving 14 months. Her law license was permanently revoked. She'd found work as a paralegal at a small personal injury firm in Phoenix. A second chance, but not in the career she'd trained for. I felt no satisfaction in her downfall. Her choices had destroyed multiple lives, including her own. The legal profession had lost someone with genuine talent. Clients had suffered financial losses. Trust had been shattered. But justice had been served. The system had worked, eventually. My phone buzzed with a text from a former client. Their commercial development project had been completed successfully. The financing issues we'd resolved were now just a memory. Outside my window, the Arizona sunset painted the mountains in shades of gold and crimson. Another day in the legal profession was ending. Tomorrow would bring new challenges, new clients, new opportunities to build trust. The betrayal had taught me valuable lessons about human nature and professional responsibility. Those lessons would guide my practice for years to come. It was finally over, and the silence felt earned.